Nadia, you are live.
Hello everyone and welcome to this session of CLAT Point. अब ये बात सब लोग कहते हैं, हर बार कहते हैं कि मॉक टेस्ट बहुत ज़्यादा ज़रूरी हैं. फॉर एनी एग्ज़ाम टू बी क्रैक्ड यू नीड टू सॉल्व मॉक टेस्ट एंड टेक देम रिपीटेडली. पर मॉक टेस्ट हर बार करने के बाद जब आपके मार्क्स आते हैं तो मैनी अ टाइम्स नहीं समझ में आता कि वो मार्क्स क्यों कम आए हैं, कहाँ पे यू गोइंग रॉन्ग, या कोई ये सॉल्व करा देता, कैसे अप्रोच करना चाहिए. तो इसके ही लिए वी हैव कम विद दिस पर्टिकुलर सेशन फॉर यू, जहाँ पे आई विल सॉल्व दिस मॉक विद यू. ये हम लोग के जो मॉक सीरीज है क्लैट पॉइंट की, ये अवेलेबल है फॉर एवरीबडी ऑन आवर टेलीग्राम चैनल. So even if you are still not a student of CLAT Point, we would want to help you and make you crack your exam. So अब हम लोग पहला क्वेश्चन लेते हैं जो कि हम लोग का एक पैसेज फॉर्म में है. जैसे कि आप जानते हैं कि इस पूरे जो सीरीज है वो उसी पे ही बेस्ड है जैसे आपका एग्जाम आएगा, और एग्जाम आपका पैसेज एंड उस पे बेस्ड क्वेश्चंस के फॉर्म में आता है. So starting with the first passage. As noticed, motive, when proved, supplies additional link in the chain of circumstantial evidence, but absence thereof cannot by itself be a ground to reject the prosecution case. Although absence of motive in a case based on circumstantial evidence is a factor that weighs in favor of the accused. अगर कोई भी केस सर्कमस्टेंशियल एविडेंस के बेसिस पे प्रूव किया जा रहा है तो वहां पे एब्सेंस ऑफ मोटिव का काफी ज्यादा फेवर अक्यूज्ड के तरफ चला जाता है. The question of motive in the present case, in our view, cannot be examined only with reference to the testimony of the wife of the appellant, who has, even while admitting that she left the children in the company of the appellant and thereafter heard only about their demise, chosen not to support the accusations अगेंस्ट द एपेलेंट. अब आपको यहाँ तक पढ़ के ये समझ में आ गया होगा कि ये किसी जजमेंट से लिया गया है, तभी यहाँ पे बात इस तरह से की जा रही है कि जैसे कि इट्स अ जजमेंट बीइंग रिटन. और यहाँ नीचे लिखा भी हुआ है कि एक्सट्रैक्टेड फ्रॉम प्रेम सिंह वर्सेस स्टेट ऑफ एनसीटी दिल्ली 2023. अब ये पढ़ते ही आपके दिमाग में पहला थॉट मोस्ट लाइकली आएगा कि ये केस तो हमने कवर ही नहीं किया है अपनी प्रिपरेशन में, आई डोंट नो अबाउट दिस केस. Still keep going on as if you are prepared for it. इसको देख के डरना नहीं है कि ये केस नहीं पढ़ा, क्योंकि जो प्रिंसिपल्स यूज हो रहे हैं वो आपने पढ़े होंगे. यू नो व्हाट सर्कमस्टेंशियल एविडेंस इज, यू नो व्हाट मोटिव इज, सो कीप गोइंग. नाउ even brother of the appellant, though attempted to depose against the prosecution case, but indeed testified to the fact that there had been strains in the relationship of the appellant and his wife. The submission that strained relationship of appellant with his wife may not provide sufficient motive for killing the children cannot be accepted for the reason that the motive projected in the present case had been that the appellant doubted the paternity of the deceased children and suspected that they were not his sons. We are clearly of the view that when the evidence on record unambiguously proves the guilt of the accused appellant, the factor relating to motive cannot displace or weaken the conclusions naturally flowing from the evidence. Differently put, in our view, when all the facts and circumstances are taken together, the present one is not a case where there had been any missing link in the chain of circumstances. Circumstantial evidence कि आप जितने भी केस लॉज पढ़ेंगे उसमें सब में दिस इज वन थिंग विच इज रिपीटेडली सेड कि कोई मिसिंग लिंक नहीं होनी चाहिए, लीडिंग ओनली टू द कंक्लूजन ऑफ द गिल्ट ऑफ द एपेलेंट. Further, कोर्ट ने क्या कहा है? It remains tried that the burden of proving the existence of circumstances so as to bring the case within the purview of Section 84 IPC lies on the accused in terms of Section 105 of the Evidence Act. And where the accused is charged of murder, the burden of proof that as a result of unsoundness of mind, the accused was incapable of knowing the consequences of his act is on the defense. ये डिफेंस के ऊपर होता है कि वो प्रूव करें कि जो मर्डर हुआ है वो अनसाउंडनेस ऑफ माइंड की वजह से हुआ है. As duly exemplified by illustration A to the said section 105 of the Evidence Act. As noticed, the mandate of law is that the court shall presume absence of circumstances so as to take the case within any of the general exceptions in the Indian Penal Code 1860. The principles of burden of proof in the context of plea of unsoundness of mind had been stated by this court in the case of, now the cases given. अब आता है हमारा पहला क्वेश्चन कि विच ऑफ द फॉलोइंग केसेस हैज बीन रेफर्ड टू. ये बात कि प्रिंसिपल ऑफ बर्डन ऑफ प्रूफ इन द कॉन्टेक्स्ट ऑफ प्ली ऑफ अनसाउंडनेस ऑफ माइंड हैज बीन स्टेटेड बाय दिस कोर्ट इन द केस ऑफ वन. तो ये वन हम किसको कह रहे हैं? नाउ इफ यू रेड योर केसेस ऑन जनरल एक्सेप्शंस, तो आपको ये पता होगा कि इसका आंसर है बी, डीसी ठक्कर वर्सेस स्टेट ऑफ गुजरात. ओके, इसमें यही बात कही गई थी कि अगर कोई इंसान प्ली कर रहा है कि अनसाउंडनेस ऑफ माइंड की वजह से उससे मर्डर हुआ है, देन ही इज द वन हु हैज टू प्रूव इट, जैसा कि ये सारे जनरल एक्सेप्शन में होता है. मान के ये चलता है कोर्ट कि देयर इज नो जनरल एक्सेप्शन इन अ केस, इन अ क्रिमिनल केस. अगर आप प्ली ले रहे हैं कि नहीं नहीं ये नॉर्मल सर्कमस्टांसेस नहीं है, इसमें तो जनरल एक्सेप्शंस का कोई सा भी सेक्शन लग रहा है, देन यू एज अ डिफेंस हैज टू प्रूव कि यहाँ पे ये जो हम लोग की प्ली है जनरल एक्सेप्शन की वो लग रही है. ये प्रूव करना होगा कि जो इंसान था वो अनसाउंड माइंड का था, एंड दैट टू नॉट जनरल अनसाउंडनेस ऑफ माइंड, लीगल इंसैनिटी. लीगल आपको बताना होगा कि अनसाउंड माइंड में जो रिकॉग्नाइज किया जाता है वो है. सेकेंडली, यू ऑल्सो हैव टू टेल कि उस टाइम पे व्हेन द क्राइम वाज बीइंग कमिटेड, उस टाइम पे द पर्सन वाज ऑफ अनसाउंड माइंड, नॉट जनरल इंसैनिटी. ठीक है, आई होप दिस इज क्लियर. I'll just look at if you people have any questions. Let us know if you have any. I'll just move ahead. So now comes the second question on the same passage. In the following cases, it was held that the burden of proof to establish plea of alibi on the accused is very heavy. प्ली ऑफ एलिबाई क्या होता है? प्ली ऑफ एलिबाई हम लोग का एक बहुत ही मेजर एंड वन ऑफ द हेविली रिजॉर्टेड प्ली है, जहाँ पे जिसको अक्यूज किया जाता है ना किसी भी क्रिमिनल एक्ट का, वो ये स्टैब्लिश करने की कोशिश करता है कि वो उस वक्त वहाँ पे था ही नहीं. Now one person cannot be there on two places at the same time. तो यही चीज़ हमारी प्ली ऑफ एलिबाई कहती है. If for example there is a murder committed in झारखंड एंड इल्ज़ाम आ रहा है एक पर्सन ए पे. नाउ ही प्रूव्स by way of CCTV cameras, by way of electronic devices that he was in his office at that time. तो उसको plea of alibi मिल जाएगी, यानी कि he was not there at the scene and he was not near that scene जहाँ पे he could reach and commit the crime and go back. ठीक है, इसका आंसर है सी, पप्पू तिवारी वर्सेस स्टेट ऑफ झारखंड 2022. नाउ स्टेटमेंट 1, motive if proved would supply link in the chain of circumstances. Statement 2 क्या कहता है? Absence of motive favors of accused as it is a ground to reject prosecution case. अब आपको ये बताना है कि ये दोनों स्टेटमेंट्स ठीक है, एक स्टेटमेंट ठीक है, दोनों गलत है. What's the final answer? So the answer for this is C. Statement 1 is correct and 2 is incorrect. Why? Motive, if proved, would supply a link in the chain of circumstantial evidence. Now, there's no doubt about it कि ये तो ठीक ही है. Absence of motive favors the accused sorry, as it is a ground to reject the prosecution case. अभी हम लोग ने ऊपर पैसेज में पढ़ा कि only because there is an absence of motive, इसका ये मतलब नहीं है कि पूरा का पूरा prosecution case ही flat to the ground हो जाएगा. अगर prosecution case बहुत solid है and the only thing you cannot find is motive, then it might get ahead with the case. ठीक है, important होता है motive बहुत, but सिर्फ वही जरूरी नहीं होता. Now as you can see, ऊपर का ये जो पूरा passage था, इससे principles इसके उठा के उन पे question हो रहा है, motive पे, burden of proof पे, unsoundness of mind पे. उस पे क्वेश्चन नहीं है कि इस केस में किसने क्या कहा, किसने क्या नहीं कहा, because questions don't always come on that. They may, yes, but it doesn't mean कि आप केस का नाम देखते हुए उसको छोड़ दो, because it can very well be possible कि जो केस आया है, जो पैसेज है, उसका आपको ज़रा अंदाज़ा ना हो, लेकिन जो उसके नीचे क्वेश्चंस है वो आपको पता हो, जो उसमें प्रिंसिपल्स यूज हो रहे हैं वो आपको अच्छे से आते हो. ठीक है, सो स्टिल गो ऑन अटेम्प्टिंग द क्वेश्चंस गिवन इन द पैसेज. Now, what among the following statement holds true about section 329 of the CRPC? अब section 329 क्या कह रहा है? Procedure in case of accused being lunatic. That's not the answer. Procedure in case of unsound mind tried before the court. That is the answer. Now, procedure for the court to be open. Procedure in case of accused being a juvenile. अब ऐसे में also try to understand कि ये पैसेज किस पे है, अनसाउंडनेस ऑफ माइंड पे है, तो मोस्ट लाइकली आंसर क्या होगा? जुवेनाइल पे होगा? नहीं होगा. ल्यूनेटिक पे होगा? लेस चांसेस बट कैन बी. तो मोस्ट लाइकली और आंसर इज ए और बी. सी और डी के होने के चांसेस बहुत कम है, क्योंकि ओपन कोर्ट की हम बात नहीं कर रहे, जुवेनाइल का ऊपर पैसेज में कुछ दिया नहीं हुआ है. ठीक है, सो दैट इज हाउ यू नैरो डाउन योर ऑप्शंस. ठीक है, and then even if you have to guess, that is where you will call it a very calculated way of guessing things. ठीक है, तो ये एक calculated guess आप ले रहे हैं, calculated risk ले रहे हैं ऐसे questions में. Now, which of the following cases led to the establishment of principle of unsoundness as a general defense? Now, this is a very very famous case. आर वर्सेस मैग्नॉटन. आर वर्सेस मैग्नॉटन से निकले हुए जो रूल्स हैं उनको हम लोग मैग्नॉटन रूल्स भी कहते हैं. दिस इज नॉट एन इंडियन केस, इट्स एन इंग्लिश केस. हाउस ऑफ लॉर्ड्स ने इसमें पूरा लिस्ट दी थी कि क्या क्या प्रिंसिपल्स ले डाउन किए गए. ऑल्दो those principles are not extremely and fully followed, but yet it remains one of the landmark cases. Now, which of the following cases is landmark as it laid down the Panchsheel theory? अब पंचशील थ्योरी क्या है? जो आपकी सर्कमस्टेंशियल एविडेंसेस की बात होती है, उसी के लिए पंचशील थ्योरी दी गई है. एंड शरद बिरदीचंद सरदा वर्सेस स्टेट ऑफ महाराष्ट्र इज नोन केस फॉर द पंचशील थ्योरी. सो दैट इज वेयर 5 प्रिंसिपल्स कम इन जब कोर्ट्स को डिसाइड करना होता है अबाउट अ क्राइम in the light of circumstantial evidences. ठीक है, so next question is, a judge does not preside over a criminal trial merely to see that no innocent man is punished. A judge also presides to see that a guilty man does not escape. Both are public duties. In which of the following cases Justice Arijit Pasayat quoted the above statement? Now this is a very very pinpointed question. आता है तो आता है, नहीं आता है तो नहीं आता है. So the answer is C, State of Punjab versus Karnail Singh. Now हाउ कैन यू गेस इन सच केसेस? अगर ये क्वेश्चन है तो इसमें गेस वर्क कहाँ पे आएगा? जो गेस वर्क है या तो वो इस तरह से आएगा कि यू हैव एन आइडिया कि इस केस में क्या हुआ था, वरना यू हैव एन आइडिया कि अच्छा ये जो दोनों केसेस है, फॉर एग्जाम्पल यू नैरो इट डाउन टू कि अच्छा ये केस तो देखो थेफ्ट का था, ये केस था प्राइवेट डिफेंस पे, ये केस किसी और चीज़ पे, मे बी इट वॉज नॉट रिलेटेड टू एनी ऑफ दीज क्राइम्स एट ऑल, डिफेमेशन का केस था, एनीथिंग ऑफ दैट सॉर्ट. सो देन यू कैन टेक अ गेस एट सी. अदरवाइज ये वो क्वेश्चंस हैं जहाँ पे आपकी कैलकुलेटेड गेसिंग मुश्किल से होगी. सो इस पे टाइम बहुत ज़्यादा बिताने से बेटर होगा कि यू स्पेंड टाइम ऑन क्वेश्चंस विच आर लाइक दिस, स्टेटमेंट दिए हुए हैं या यहाँ पे जहाँ पे यू कैन एक्चुअली मेक अ बेटर गेस. तो गिव टाइम ऑन दोज क्वेश्चंस मोर. जहाँ पे बहुत पिन पॉइंटेड क्वेश्चन है वहाँ पे वाइड गेस वर्क करने का, ब्लैंक गेस वर्क करने का कोई मतलब नहीं है, बिकॉज यू विल एंड अप लूजिंग मार्क्स. नाउ, a person Z killed two of his sons. He pleads that no person of sane mind would kill their own children. What among the following holds true regarding the facts? Now, this is a case जो कि actually इस तरह के बहुत सारे cases हैं. यहाँ पे अभी हम लोग ने ऊपर पढ़ा भी है कि फर्स्ट क्या है, द बर्डन ऑफ प्रूफ लाइज ऑन प्रोसिक्यूशन टू प्रूव दैट जेड इज ऑफ अ सेन माइंड. ये कभी प्रूव नहीं करने को कहा जाएगा कि प्रूव करो कि सामने वाला सेन माइंड में बैठे बैठे, नहीं. ओनली इफ ही इज अलीजिंग दैट आई एम ऑफ अनसाउंड माइंड, देन जेड विल हैव टू प्रूव दैट ही इज ऑफ इनसेन माइंड. सिर्फ ये कह देने से कि अरे वाई विल आई किल माई टू सन्स, ऐसे नहीं. यू हैव टू प्रूव दैट जेड इज ऑफ इनसेन माइंड, और किसी के ऊपर ये बर्डन ऑफ प्रूफ लाई नहीं करता. कोर्ट शैल प्रिज्यूम रिगार्डिंग द इनसेनिटी ऑफ जेड, नहीं. Which of the following is not covered under section 84? अभी पैसेज पढ़ते में ही आई टोल्ड यू कि लीगल इंसेनिटी इज व्हाट मैटर्स, मेडिकल इंसेनिटी डज नॉट मैटर. ठीक है, तो नाउ यू नो कि सी एंड डी ऑब्वियसली आंसर नहीं हो सकते बिकॉज लीगल इंसैनिटी इज कवर्ड, तो मेडिकल इंसैनिटी इज नॉट कवर्ड. ऐसा बिल्कुल हो सकता है कि मेडिकल टर्म्स में अ पर्सन इज इंसेन बट लीगल टर्म्स में ही इज नॉट. लीगल टर्म्स में इंसेन सिर्फ तब माना जाता है व्हेन देयर इज लैक ऑफ कोऑर्डिनेशन बिटवीन ऑल द सेंसेस. ठीक है, मेडिकल इंसैनिटी इज समटाइम्स वेरीड with the legal insanity. Now 10th, the magistrate of first class convicted X for the commission of offence of section 379 and imposed fine of 10,000 rupees as punishment. However, X committed default of fine. In light of the concerned provisions, X will be liable to undergo imprisonment of, ये भी बहुत ही पर्टिकुलर साउंड करता है क्वेश्चन कि यू नो अब हमको ये पता है कि नहीं पता है कि सेक्शन 379 में क्या दिया है. लेट्स प्रिज्यूम कि ये नहीं दिया हुआ है, आपको नहीं याद है 379 आईपीसी क्या है, बट मैजिस्ट्रेट ऑफ फर्स्ट क्लास की पनिशमेंट कितनी हो सकती है ये तो पता होगा, है ना. तो दे कैन नॉट पनिश अ पर्सन फॉर मोर देन 3 years एनीवेज. ठीक है, सो योर आंसर विल बी ए. Not because you know section 379 IPC, but because you know कि magistrate of first class कितना punish कर सकता है. So, see the question fully. किसी भी चीज़ को देख के डर नहीं जाना है कि अरे ये नहीं आता. Even if we say कि आपको ये passage के बारे में कुछ नहीं पता था, even then from the passage you will end up answering at least 3 questions. At least 3 questions and that too correctly. 3 से बल्कि ज़्यादा ही. 9 is a concept which you know. 10th I told you how it can be done. ठीक है, तो 2 questions ही हो गए. Now 8th again it's a principle. You know ये burden of proof किस पे जाता है. 7 we are not counting. पंचशील थ्योरी का शरद बिरतीचंद is a landmark case. Landmark cases पता होते हैं usually. I am not taking this one as a landmark case because this is not a landmark case. ठीक है, so 4 Magnotta rule everybody of us know because आप लोग LLM का एग्जाम दे रहे हो, सो प्रिज्यूमिंग यू विल बी नोइंग. तो ये 5 हो गए. ये वाला you can guess as I told you, but even if I don't take it, it's fine. And ये आपका statement. So in a question where you have no idea कौन से केस से उठा के आपको सवाल पूछा जा रहा है, you are able to answer 6 questions out of it based on principles and the knowledge you have gained while giving your LLB. ठीक है? Now let's see if you people are keeping up the pace. Let me know if there's anything which you want me to repeat or you want me to slow down with. Okay? Now, the next passage. Coal continues to be an important and scarce natural resource. Nothing more is required to establish the same that the very less over it. It forms an important raw material in the production of vital final products. Also, it forms a kind of fuel which drives the power plant. A monopoly undoubtedly stood created by Nationalization Act. The mines which were subject matter of the act stood vested with the central government. Nationalization जब हुआ था तो central government के पास ये सारी चीजें चली गई थी. The first appellant is a government company which came into being as contemplated under Section 5 of Nationalization Act. The appellant company operates the mines. It is tasked with the power and the duty to distribute coal. This attracts the directive principles enshrined under Article 39B. The said directive principle contemplates that the state should direct its policy towards securing the ownership and control of material sources as so distributed so as to serve the common good. The argument of the appellant is partly based on the dictates of Article 31B, which together with the ninth schedule, the insertion in which schedule immunizes law from being invalidated on the ground that they take away or abridge fundamental rights. The Nationalization Act was inserted in the ninth schedule on 10th August 1975. We are not in this case called upon to sit in the judgment over the insertion of Nationalization Act on the basis that it violates the basic structure of the Constitution in terms what has been laid down in I.R. Coelho case. Now, we proceed on the basis, therefore, that the Nationalization Act was insulated by virtue of Article 31B. Equally, we proceed on the basis that it can be treated as a law giving effect to the policy of the state towards securing the principles enshrined in Article 39B. अब ये कहाँ से एक्सट्रैक्ट किया गया है? कोल इंडिया लिमिटेड वर्सेस कॉम्पिटिशन कमीशन ऑफ इंडिया 2023. अब ये केस बहुत ज़्यादा टॉक्स में था बिकॉज ऑब्वियसली एक बहुत बड़ी कंपनीज वर इन्वॉल्व्ड इन दिस. सो लेट्स सी कि what are the questions based on it. Now the first question is that anti-competitive agreements क्या होते हैं? Void होते हैं, voidable, valid, invalid. अब we all know the basic concept कि भाई competition market में रहेगा तो ही इकोनॉमी को फायदा होगा और कंज्यूमर्स को फायदा होगा. तो एंटी कॉम्पिटिटिव अग्रीमेंट्स जो होते हैं दे आर वॉइड अग्रीमेंट्स. ठीक है, दे आर नॉट सीन एज वैलिड. नाउ द एंट्री माइंस बिलोंग्स टू विच लिस्ट इन द इंडियन कॉन्स्टिट्यूशन. यहाँ पे सबसे पहला आपको ये सोचना है बिकॉज एंट्री नंबर याद हो ये मुश्किल है. ठीक है, तो वहां से नहीं शुरू करेंगे. इसको कहाँ से शुरू करेंगे कि लिस्ट 1 में है, 2 में है, 3 में है या 1 2 3 तीन ही लिस्ट है. सी माइंस का जो पूरा सब्जेक्ट मैटर है, सो लॉ एंड पॉलिटिक्स इज एंटैंगल्ड. ठीक है, यू हैव टू बी रीडिंग न्यूज़पेपर्स, यू हैव टू बी अंडरस्टैंडिंग द होल कॉन्सेप्ट ऑफ हाउ द स्टेट वर्क्स. माइनिंग किसकी होती है? नेचुरल रिसोर्सेज की. डू यू थिंक नेचुरल रिसोर्सेज जितनी इंपॉर्टेंट चीज जैसे यू नो कोल एंड एवरीथिंग will be given to state? No. Natural resources will be kept with the central government. ठीक है, सेंट्रल गवर्नमेंट यानी कि आपकी यूनियन लिस्ट आ गई. यूनियन लिस्ट से मतलब हो गया हमारा लिस्ट 1. Now after this, yes, you have to see if you remember the entry number. ठीक है, लेकिन मान लेते हैं कि यहाँ पे लिस्ट वन का सिर्फ एक ही दिया होता ऑप्शन, यू वुड हैव बीन सॉर्टेड. ठीक, अभी यहाँ पे ऐसा नहीं है एंड द आंसर इज एंट्री 54 ऑफ लिस्ट वन. सो इवन इफ यू हैव टू मेक अ गेस, you know that you have to make a guess between A and B, even when you don't know कि माइंस जो है वो किस लिस्ट में है. बट फ्रॉम कॉमन सेंस यू कैन मेक इट आउट कि ये ऐसा सब्जेक्ट है, सब्जेक्ट मैटर जो स्टेट्स को नहीं दिया जाएगा. कॉन्करेंट रखा गया तो कितनी उधम होगी, वेयर स्टेट एंड सेंटर बोथ हैव द पावर. ठीक है. Now, which of the following cases is known as the bank nationalization case? Very, very famous case. Also, if you have read law-related novels or books rather, like Nani Palkiwala's book, and I think it has been mentioned in several other books. But I would suggest that अगर कोई और भी बुक नहीं पढ़नी है तो भी read Nani Palkiwala's book, because that has covered all these cases in a beautiful manner. ठीक है. Having said that, the answer we know, R.C. Cooper versus Union of India 1970. बहुत ही लैंडमार्क केस है and it is famously known as the bank nationalization case. Now, ninth schedule was added by which constitutional amendment? ये हम लोग का सबसे पहला जो कॉन्स्टिट्यूशनल अमेंडमेंट हुआ था उससे नाइन्थ शेड्यूल ले आया गया था. ठीक है. ऑल्सो लर्न कि जितने भी शेड्यूल्स ऐड किए गए हैं वो किन किन कॉन्स्टिट्यूशनल अमेंडमेंट से किए गए हैं. दैट्स इंपॉर्टेंट. यू शुड नो एवरी शेड्यूल विच हैज बीन एडेड थ्रू विच कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. मोस्ट लाइकली एक पे तो सवाल आ ही जाता है. ठीक है. सो हियर गोज योर वन सेफ क्वेश्चन. In which of the following cases 31C of the Indian Constitution was declared invalid on the grounds of exclusion of judicial review? Now, 31C के और ये सारे cases are quite famous cases. केशव नंदा भारती में ये चैलेंज हुआ था और इसको इसी ग्राउंड पे हटाया गया था कि भाई आप जुडिशियल रिव्यू को नहीं हटा सकते हैं. Why? Because it is one of the basic structures of the Constitution. Now, which of the following cases does not relate to sovereign immunity of the state? This one is a very pinpointed question. This is not where I would suggest you to guess. Answer is Kaliram versus State of Himachal Pradesh 2023. If you know, you do. If you don't take guesses. Unless, yes, you can take a guess by exclusion. If you know any other cases coming from some other subject matter तो ठीक है. अगर आपको पता है कि बाकी cases किससे डील कर रहा है तो great. By exclusion you can answer your question. अगर ऐसा नहीं है then ऐसे questions पे guess नहीं करना है. The word common good under section 39 of the Indian Constitution is based on which of the following jurists? Poland, never talked about common good. Austin, now we know कि जो ऑस्टिन है he had a very very sovereign एक होता है, उसकी सारी बातें मानो, कमांड ये वो. Salmond also was of the similar theory. Bentham is the answer, wherein he talked about greater number, greater good. इन सारी बातों का आंसर Bentham ही होता है हमेशा. Now, which of the following goals does not fall under Article 39? 39 A, B, C, D करके there are number of subsections. I will recommend कि आप सब articles. I will recommend कि आपको section 39 के सारे clauses याद होने चाहिए. ठीक है. Does not fall में है equal justice and free legal aid, because this falls under section 39A. अलग से add हुआ था ये. Now, whether the principle king can do no wrong is applicable in the Indian context. So, king can do no wrong is something जो British उससे आता था. There is no king in India. There is government which is elected. किसी भी democracy में it is not possible. Article 300 में हम लोग बात करते हैं central government की, और ये कोई भी king can do no wrong का concept नहीं है, because under Article 30 एज पर आर्टिकल 30 जो आप केस करेंगे गवर्नमेंट ऑफ इंडिया पे, यू कैन सू द गवर्नमेंट एंड यू कैन बी सूड बाय द गवर्नमेंट अंडर द नेम ऑफ गवर्नमेंट ऑफ इंडिया, ठीक है, या यूनियन ऑफ गवर्नमेंट, यूनियन गवर्नमेंट। सो ऐसे में ऑब्वियसली ये बताता है कि इफ यू कैन सू द गवर्नमेंट तो किंग कैन डू नो रॉन्ग का तो कोई सवाल ही नहीं बनता। एंड वी ऑल्सो डू नॉट कीप द इंडियन गवर्नमेंट इन द प्लेस ऑफ दैट किंग, ठीक है, ये कॉन्सेप्ट इंडिया में नहीं है। सो यू नो द आंसर इज नो, बट हाँ 299 होना है या 300 होना है, दैट कैन बी कंफ्यूजन। 299 as it is talks about contracts which are entered by the government. 300 talks about suing and being sued, from the perspective of the government. Which of the following cases does not relate to tortious liability of the state? Here comes your torts. Torts के ये सब cases, learn them. This is particularly a new case where because of which it can be asked. बहुत ही कम हम लोग के torts के cases आते हैं, so yeah, do keep a track on them. Ombudsman versus State 2023. Now coming on the third passage. So we have solved two passages. यहाँ पे the time that we are taking will not be and should not be honestly the time that you people take there. Why? Because यहाँ पे I'm explaining, वहाँ पे ये तो करना नहीं होगा. So read your questions quick and make your answers quicker. Quick का ये मतलब नहीं है that you start giving wrong answers. जहाँ पे भी confusion है, I would suggest make 2 symbols. जो क्वेश्चन अटेम्प्ट कर लिया वो तो कर लिया, जहाँ पे कंफ्यूजन है, सोचने पे समझ में आ जाएगा क्या आंसर होना है, जस्ट पुट अ क्रॉस और एल्स एनसर्कल इट, कोई भी एक चूज कर लो, ठीक है, प्रॉब्ली जस्ट एनसर्कल इट कि ये वाला भी देखते हैं थोड़ी देर में आगे। जो सवाल बिल्कुल नहीं आता, वाइल्डेस्ट केस नहीं पॉसिबल है उसके लिए, जस्ट पुट अ क्रॉस ऑन इट। तो जब आप रिवाइज भी कर रहे होगे, जब आपको टाइम मिलेगा आफ्टर बीइंग डन विद योर 10% क्वेश्चंस कि हाँ ठीक है इतने तो आते ही आते हैं, तो यू विल नॉट बी वेस्टिंग टाइम इन रीडिंग ऑल ऑफ द क्वेश्चंस लेफ्ट अगेन। यू नो कि अच्छा ठीक है सेकंड ट्राई इन पे करना जो क्रॉस वाला है, ठीक है। तो सेग्रीगेट योर क्वेश्चंस इन दैट मैनर। सब पे ही अगर सर्कल कर दिया तो फिर आप सारे क्वेश्चंस पढ़ रहे होगे, वाइल वी नो कि कुछ क्वेश्चंस ऐसे होते हैं कि बिल्कुल नहीं पता होते हैं, which is fine. You don't need to worry about it. Now coming to the third passage. The reason as to why the central government cannot unilaterally issue gazette notification but has to resort to a legislation when it initiates the proposal for demonetization has already been discussed. Now we know कि case किस पे है, demonetization पे. The central government may have very valid objectives to do so, as in the instant case, that is, in order to eradicate black money, fake currency and prevent currency from being utilized for terror funding. But those objects would not be the objects with which the central board of the bank may make a recommendation under section 26 clause 2 of the act. The reason being the central government would view the entire scheme of demonetization in a large perspective, having several objects in mind and in the interest of the sovereignty and integrity of India, the security of the state, financial health of the economy, etc. The central board of the bank may not be in a position to visualize such objectives. Under such circumstances, the central government must consult the bank but need not mandatorily obtain the imprimatur of the central board of the bank to its proposal. हम ये समझ गए कि वो केस है जो कि डिमोनेटाइजेशन के अगेंस्ट हुआ था एंड जहां पे डिमोनेटाइजेशन को वैलिड बताया गया था. What if the central board of bank, when consulted by the central government, gives a negative opinion? Would it mean that the central government would not resort to the demonetization in deference of the opinion of the central board of the bank? It may do so if it finds that the opinion tendered by the bank is just and proper. But central government may have its own reasons for not accepting the opinion of the central board of the bank, and therefore, in such a situation, the central government will have to resort to initiate the proposal for demonetization through a plenary legislation by way of introduction of a bill in the parliament resulting in an act of parliament. Therefore, The sum and the substance of the discussion is that when central board of the bank initiates or originates the proposal for demonetization of any series of banknotes or any demonetization, it has to make a recommendation to the central government as per section 26 clause 2 of the act. The central government may act on such recommendation by issuing gazette notification. On the other hand, when the central government is the originator of the proposal, ये हम लोग को पता है कि originator अगर नहीं है तो किस तरह से रहना है. But if the central government is the originator of the proposal for demonetization of any currency note in an instant case, it has to seek the advice of the central board of the bank, for it cannot afford to proceed in isolation and without bringing such said proposal to the notice of the central board of bank, having regard to the important position the bank holds in the Indian economy. यहाँ तक कि आई होप आपको समझ में आ गया हो कि किस बैंक की बात हो रही है. ऑब्वियसली रिजर्व बैंक ऑफ इंडिया की ही बात हो रही है, क्योंकि और कोई बैंक नहीं है ना. किसी प्राइवेट बैंक के लिए तो इतनी मेन पोजीशन दी नहीं जाएगी. Bank holds in the Indian economy. Irrespective of the opinion of the central board of the bank to the central government's proposal, the legislative rule would have to be taken by the central government for furthering its objectives of demonetization of banknotes. Thus, the same cannot be carried out by the issuance of simple notification in Gazette of India declaring that all banknotes or currency noted are demonetized. This is because when the central government is the originator of the proposal for demonetization, it is acting de horse subsection 2 of section 26 of the act. ये extract किस judgment से है ये नाम नहीं दिया गया है, which obviously makes us realize कि पहला question यही होगा. ठीक है, so it's विवेक नारायण शर्मा वर्सेस यूनियन ऑफ इंडिया. ये हैं हम लोग के judges who were there. Now, if you would know कि इस केस में dissenting opinion था. Dissenting opinion was very very famous because it was by Justice Nagarathan. I'm sorry if I'm pronouncing it wrong. Now she is, if the collegium system goes as it does, she is expected to be the first female Chief Justice of India. Let's hope. So she had given this dissenting opinion, which is why this was a lot in talks, you know. Otherwise, it was held that demonetization is legal, but she had given a dissent, and this is actually an extract from that dissent, as you could read. Now, which of the following act has been referred in extract of in the extracted stated above? Section 22 clause 26 clause 2 बार बार रेफर हो रहा है. किस एक्ट से हो रहा है? अब मान लेते हैं कि केस के बारे में सुना तो था, बिकॉज ऑब्वियसली डिमोनेटाइजेशन चैलेंज हुआ, एवरीबडी नोज, पर पढ़ा नहीं था केस. अब हम यूज करेंगे अपनी कॉमन सेंस. बैंक की बात हो रही है, एज आई सेड, ऑब्वियसली इट्स रिजर्व बैंक ऑफ इंडिया. ठीक है, सेक्शन 26 क्लॉज 2 में जहाँ जहाँ ये बता रहा है, ये बार बार इट इज टॉकिंग अबाउट हाउ व्हाट इज द रोल ऑफ द बैंक, हाउ दे हैव टू गो अबाउट इट. यानी कि it is the Reserve Bank of India Act that is being talked about. And anyhow, this is the most likely answer from all of this. Banking regulations की बात नहीं हो रही है यहाँ पे, demonetization की बात हो रही है. कहा जा रहा है that this one bank is the most important thing. तो वो Reserve Bank of India है, and your answer is Reserve Bank of India Act 1934. Even if you have not read, this is the, according to me, possibly this should be the only wild guess that you can take. Now, which of the following is correct as per dissenting judgment? Dissenting judgment के हिसाब से क्या ठीक है? Section 26 clause 2 of the act applies only when a proposal for demonetization is initiated by the central government by way of a recommendation being made to central board of the bank. It was observed that demonetization was an initiative of the central government targeted to address dispirited evils plaguing the nation's economy, including practices of hoarding black money, counterfeiting, which in turn enables even greater evils, including terror funding, drug trafficking, emergence of parallel economy, money laundering, including hawala transactions. C. The power under 26 clause 2 of the Act can be construed to mean all series of all denominations. The central government may also initiate and carry out demonetization even in the absence of a recommendation by the central board of the bank by issuance of a notification. So what is actually 26 clause 2 saying? ये चीज हम लोग को ऊपर वाले पूरे पैसेज को पढ़ के समझ में आ भी जाएगा. That the answer is B. It was observed that demonetization was an initiative of central government targeted to address all the evils and everything. जो हम लोग ने ऊपर काफी clearly देखा कि लिखा हुआ था in all the passages that were being quoted. So here we are done with half of it. अब आते हैं हम लोग 25th पे. Which amongst the following is the author of the majority judgment? अब minority का तो पता है, तो majority judgment किसने दिया? Majority judgment was given by Justice Gawai. In which of the following cases, Supreme Court held that the word anything provided in Article 105 is equivalent to everything. ठीक है, anything is equal to everything की बात किस केस में कही गई थी? The answer is Tej Kiran Jain versus N. Sanjeeva Reddy. The maxim ut res magis valet quam perit is also known as, ये एक पूरा maxim जो कि अक्सर होगा कि at least one question you can expect कि वो maxim से पूछ ही लेंगे. If not, great, lucky, but mostly it's there. ये बताता है rule of reasonable construction को. ठीक है, this maxim is for rule of reasonable construction. Now, which of the following is not a prong in a test of proportionality? Test of proportionality क्या होता है कि जो action है उससे related ही reaction हो, उसके proportion में हो. ठीक है, so which of the following is not prong in the test of proportionality? A measure restricting a right must have a legitimate goal. Seems proportional. It must be a suitable means of furthering the legitimate goal. Again, sounds logical. There must not be any less or more restrictive but equally effective alternative. Doubtful. The measure must not have a disproportionate impact on the right holder. ये तो एकदम ही सही है. So your answer is C. There must not be any less or more restrictive but equally effective alternative. This is not really practical. इतना ज़्यादा proportional means proportional, not exact. Which of the following doctrine was discussed in the case of the Registrar of Cooperative Societies, Trivandrum, and another versus K. Kunjabmu and others? I'm very sorry for pronouncing it wrong. This is AIR 1980. लेकिन इस केस में किस डॉक्ट्रिन की बात हुई थी? It was doctrine of excessive legislation. Again, this is not something that can be guessed. जो नहीं guess हो सकता है उसमें एकदम से guess करके don't make your chances low by losing the score. Now, statement 1. Wisdom and advisability of economic policy are ordinarily not amenable to judicial review. Statement 2 क्या कहता है? Courts does not have power of judicial review in case of matters relating to economic policy. Now, which one is correct, which one is not correct? ये जो second statement है कि economic policy में judicial review ही नहीं है. Now, this is something जो कि power of judicial review को curb कर रहा है. We have seen, read 100 times that judicial review is one of the basic structures. तो ये तो हो नहीं सकता. पहला क्या था कि wisdom and advisability of economic policy are ordinarily not amenable to judicial review. कोई भी advice जो दी जाती है that is not under the purview of judicial review. This is, you can take it as a fact which applies to all the cases कि अगर कोई भी किसी को कुछ advice कर रहा है, काउंसिल ऑफ मिनिस्टर्स भी advice कर रहे हैं प्रेसिडेंट को, तो वो जुडिशियल रिव्यू में नहीं आता. हाँ, जज पूछ सकता है कि आपने क्यों एडवाइस किया, क्या एडवाइस थी, लेकिन वो जुडिशियल रिव्यू के अंडर नहीं आ सकती. यू कैन नॉट होल्ड बाय सेइंग कि एडवाइस ही इट वाज अनकॉन्स्टिट्यूशनल. दिस डज नॉट हैपन. सो वी आर डन विद 3 passages. नाउ कमिंग टू 4th one. just 1 second. Videos. Try solving the mock papers by yourself. Um, we have them available for free on our Telegram channel for everybody to prepare. Now we'll move on to the next passage. अब ये passage क्या है? The output of the first meeting of the emergency special session on Ukraine, resolution ES 11/1, did not go as far as some of these prior resolutions, but it did return to a legal characterization that it has long avoided aggression. It deplored in the strongest term of the aggression by the Russian Federation against Ukraine in violation of Section 2, Clause 4, Article 2, Clause 4 of the UN Charter, and condemned Russia's declaration as to the necessity of this special military operation. It demanded Russia to cease its use of force against Ukraine, as well as to immediately, completely, and unconditionally withdraw all of its military forces from the territory of Ukraine within its internationally recognized borders. It also condemned all violations of international humanitarian law and violation and abuses of human rights, demanding that parties to the conflict fully comply with their obligations under international humanitarian law to spare the civilian population. It recalled the obligation under A of Union Charter. Now we know कि A आया है तो ये पूछा जाएगा कि A क्या है? That all the member states, in order to ensure to all of them the rights and benefits of membership, shall fulfill in good faith the obligations assumed by them in accordance with the UN Charter. Now, Resolution ES 11/1 is unlikely to be in the General Assembly's final word of Ukraine situation. The emergency special session is now adjourned, but can be resumed in the future upon request from the member states. Although it is impossible to predict how this unfolding crisis is resolved, it's worthwhile considering the legal options open to the Assembly in seeking to secure peace and, in time, justice for victims of aggression and other international crimes. To what extent is the Assembly able to take action or otherwise recommend measure to the membership that would be legally analogous to that taken by Security Council? ये एक्सट्रैक्ट है जो यूक्रेन पे सेशन हुआ था, स्पेशल सेशन, उससे. ठीक है. नाउ एज एक्सपेक्टेड जो ए पूछा गया था, ए इनफैक्ट बोला गया था यूएन चार्टर के लिए, तो वो क्या है? विच सेक्शन इज दैट? 2 तो है, यू नो, बिकॉज द ओनली ऑप्शन इज 2. द आंसर इज 2 clause 2. ठीक है. नाउ 32. When UN General Assembly adopted the resolution which provided for emergency special session. Emergency special sessions होंगे, ये बात कब अडॉप्ट की गई थी? The answer is 3rd November 1950. The request for emergency session can be made by emergency session का अब कोई तो request करेगा. So the question is कि who is to request that? The answer is Security Council on vote of any 7 members. उन 7 में से कोई भी मेंबर अगर वोट कर देता है कि हाँ स्पेशल सेशन होना चाहिए है, तो वो होगा इमरजेंसी सेशन. इन केस ऑफ इमरजेंसी स्पेशल सेशन, जनरल असेंबली कैन मीट विद इन, अब सी जनरल असेंबली से रिलेटेड या सिक्योरिटी काउंसिल, बेसिकली पूरे यूएन से रिलेटेड, यू शुड नो एवरी क्वेश्चन ऑन इमरजेंसी स्पेशल सेशन. व्हाई? Because it was a news, we knew that it has been taken. तो आपको हर न्यूज़ का एक लीगल एस्पेक्ट देखना होगा, ठीक है, क्योंकि ये ऐसे गेस वर्क नहीं होगा ना. 24 आवर्स ऑफ रिक्वेस्ट में उन लोगों को मिलना होता है. Assertion: emergency special session is called when the Central Council, Security Council, fails to exercise its primary responsibility for the maintenance of international peace and security. So अपने आप में फर्स्ट यू हैव टू थिंक कि किसका काम है. सिक्योरिटी काउंसिल इज द प्राइमरी बॉडी ऑफ यूएन. तो अगर वो इंटरनेशनल पीस और सिक्योरिटी नहीं रख पा रही है तो इमरजेंसी सेशन इसीलिए होगा. ठीक. रीजन क्या है? सच फेलियर अकर्स ड्यू टू इनएबिलिटी ऑफ द मेंबर्स ऑफ सिक्योरिटी काउंसिल टू रीच एट अ कंसेंसस. सिक्योरिटी काउंसिल कंसेंसस पे रीच करे इज नॉट द पॉइंट, बट ठीक है. अगर वो लोग कंसेंसस पे रीच कर भी जाएं तो इस वजह से उसका फेलियर नहीं होगा। उसका फेलियर क्यों होगा? क्योंकि बहुत सारे नेशंस है विच आर इन्वॉल्व एंड स्पेशली द फाइनल वंस, राइट? तो इसीलिए ए इज ट्रू एंड बी इज फॉल्स। On which of the following grounds General Assembly will consider a need for emergency special session? ऐसा क्या होगा? Breach of peace, threat to peace, act of aggression, all of the above. Now, this is a very easy guess, right? Because it is all of the above. Act of aggression, threat to peace, breach of peace, most of them are the same. Which emergency session dealt with illegal Israeli occupation in occupied East Jerusalem and the rest of the occupied Palestinian territory? Now, this is an important question from today's standpoint. The answer is C. It was a 10th session. 10th emergency session जो हुआ था, it was about the illegal Israeli occupation of the Palestinian territories. Which of the following is incorrect in accordance with the theory of old and new wars? क्या है हम लोग के theories? The new wars are characterized by an increase in violence and an increased ratio of civilian to military casualties. The old wars, in the old wars, the state has lost its monopoly of military forces. Its authority is being challenged by various non-state actors. The new emerged war economy is central characterized of new wars, and it differs itself from more conventional war economy by being globalized, decentralized, and having low participation rate as well as high unemployment rate. And D है all of the above. So the answer is, as we know, कि old wars में क्या होता था कि state जो है अपनी monopoly of military forces lose करती थी. Its authority is being challenged by various non-state actors. This was World War II के time पे, but the theory है of old and new wars, it does not comply with it. This again is a question which cannot be guessed. Now, rational material jurisdiction means. So again, this is related to international law. If you know, you know. If you don't take a wild guess unless आपको at least कुछ अंदाजा ना हो. The answer is subject matter jurisdiction. ठीक? Which of the following factors was not required to be proven by prosecution in Tokyo War crimes trial? The war crimes were systematic, not required. ठीक है? The war crimes were systematic. The war crimes resulted in causing atrocities. The accused knew that troops were committing atrocities. The accused had the power or authority to stop the crime. The answer is B. The war crimes resulted in causing atrocities. ठीक है, this is not required to be proven because obviously war crime है तो ये atrocities तो होंगी ही होंगी, right? So far we are going well. PDF, Tisha, this is available on the Telegram channel. So please feel free, have a look, and there you will get the PDF. Now, we'll come on to the next passage. Now, this is jurisprudence. Jurisprudence is not, in fact, even international law is not very easy to cover. इस पे क्वेश्चंस आते हैं, दोनों सब्जेक्ट्स पे क्वेश्चन आते हैं. ये दोनों सब्जेक्ट्स बहुत वास्ट हैं एंड उतने ज़्यादा डिटेल में हम लोग को पढ़ाए भी नहीं जाते हैं हम लोग के लॉ स्कूल्स में. बट विद बोथ ऑफ देम, not actually both of them, but with specially jurisprudence, you can still have guess. International law का yes, जैसे 40th question था, that was okay, common sense probably, but otherwise जो international law questions हैं, don't spend a lot of time thinking if you need to answer them or not if you don't know the answer, because if it's a principle that is being asked, yes you can answer it, but प्रिंसिपल्स जो इंटरनेशनल लॉ में है वो बहुत स्पेसिफिक हैं, बहुत सारे लैटिन टर्म्स हैं, So if you're making a guess, then make sure कि you have some level of surety in that answer. Now, historically, the oldest and longest continued use of term law in jurisdiction writing is to mean aggregate of laws, the whole body of the legal precepts which obtain in a given politically organized society. This meaning was generally assumed in definition of law from Middle Ages to the end of 18th century. Law was an aggregate of laws, and a law was an authoritative rule of conduct for individual man. Bentham put it so, and such was generally the position of English analyst and analytical jurist. Sorry. It became a practical question recently in what is likely to prove a leading case under the new Constitution of State of Jersey, New Jersey. The Constitution provided the Supreme Court shall make rules governing the administration of all courts in the state and subject to the law, the practice and procedure in such courts. The court held that the word subject to law referred to substantive law, not to future or past legislation as to details of procedure, but substantive law, established either by common law or by legislation. Law is a broader term than laws or than a law. The latter term refers to the single items of one of the elements in law, in but one of the three senses of the term which must be distinguished. One of those meanings is what is now called the legal order, ordre juridique. Um, no, I can't pronounce this. Redstronach, the regime of adjusting relations and ordering conducted by systematic application of the force of a politically organized society. This regime is the most highly developed form of social control in the modern world. It is a specialized form of social control carried on with a body of authoritative precepts and applied in a judicial and administrative process. After law had been defined by the Greek philosophers and Roman jurists, and by philosophers, publicists, jurists, and lawyers, from Thomas Aquinas to Grotius to Pfaffendorf and Hobbes and Blackstone in terms of law or rules of law. Kant at the end of 18th century applied the term to the condition which the body precepts bring about or seeks to bring about, and so came near to the idea of legal order. Later formulas were put in terms of the legal order, thought of as a process rather than a condition. ठीक है, तो हमने लॉ लीगल ऑर्डर के बारे में एक सवाल पढ़ लिया है. According to which of the following the maker of the law or political sovereignty decides the validity of the law? ये कहाँ कहाँ जाता है कि वैलिडिटी वहीं प्रोवाइड करेंगे. Now this is legal positivism. Historical school में ऐसा कुछ नहीं था, we all know. So A नहीं है तो D भी आंसर नहीं है. Legal positivism is known for this कि जो maker है वो ही सब कुछ करेगा. So the answer is legal positivism. 42. Which of the following theory provides that morals are the major or main source? History में तो morals की बात हो नहीं रही है. Social contract theory, we know that it's given by 3 people and none of them are talking about morals. C. Legal theory, nahi. So the answer is D. Natural law school जो है, that talks about the morals being the main source of law. Who among the following are historical political thinkers of law and jurisprudence? Austin, everybody knows Austin का theory and he is not. Hart, no. Aquinas भी इसमें नहीं गिने जाते हैं historical thinkers में. Koch is one of the historical political thinkers. Now, 44. Who among the following jurists is known to be the follower of ideas and philosophies of Socrates under the natural school of jurisprudence? Now we know that Plato was the disciple of Socrates. Dash gives the theory of forms and said that it is independent of society and human minds. Now Plato ही की वो theory थी जहाँ पे he gave theory of forms and said that independence of society and human minds. Now Dash defined jurisprudence as science of law, whereas Dash defined jurisprudence as formal science of law. So again, I think Austin is one of the most read jurists. तो आपको ये पता होगा that he did define jurisprudence as science of law. तो जहाँ पे पहला ऑस्टिन दिया हुआ है, we narrow it down to that. जिससे हम लोग का narrow down कहाँ पे हुआ है, A और B में. Now it's Holland who has defined jurisprudence as a formal science of law. ठीक है, the word formal has come from Holland. अब ये कैसे याद रहेंगी ये सारी चीज़ें? सो मेक योर ओन वे ऑफ लर्निंग jurisprudence की डेफिनेशंस आती हैं, इसी तरह से क्वेश्चंस पूछे जाते हैं. जैसे साइंस ऑफ लॉ आ रहा है, सो ऑस्टिन की थ्योरी इज़ वेरी सिंपल. ऑस्टिन हैज़ बीन वेरी स्ट्रेट विद व्हाट ही थिंक्स. You may or may not agree, that's not the question, and that won't even be asked. So science of law हमेशा ऑस्टिन ने बोला. Some things you can make out some silly methods, जैसे हॉलैंड की बात जब भी आएगी वो एक फॉर्मल वर्ड आएगा आपका. ठीक है, ये कैसे याद करें? हॉल क्या होता है? हॉल इज अ प्लेस वेयर फॉर्मल सेरेमनीज आर कंडक्टेड. सो प्रॉब्ली यू कैन मेक दैट एज योर लर्निंग पॉइंट कि हॉल अच्छा यानी कि फॉर्मल. सो हॉलैंड सेड व्हाट? फॉर्मल साइंस ऑफ लॉ. If these methods work for you, then learn jurisprudence in that way only, because there is no other way of learning jurisprudence. The other only method is, which is obviously the best method, that you actually understand the theories that these people have said. तब क्या होता है कि अगर आपको एग्जैक्ट वो नहीं पता होगा ना, कोट जो दिया है एक जुरिस ने, तो भी यू विल बी एबल टू अंडरस्टैंड कि ये कोट कहाँ से आ सकता है. हु वाज द थिंकर हु थॉट इन दैट मैनर कि ये बोले. Now you don't have time to read all the theories. If you have done that, great. If you haven't, use these methods. Now, true law is the right reason in agreement with nature. ये किसने बोला? ऑस्टिन ने तो नहीं बोला. We know that. अब हम लोग बात कर रहे हैं रोमन से भी नहीं बोला. Naturalist is something you can get confused with, but he is not the one. They are not the ones. It's Cicero. Cicero ने बोला था कि true law is right reason in agreement with nature. The traditional legal philosophies at the time were Kelsen claimed hopelessly contaminated with political ideology and moralizing on one hand, or with attempt to reduce law to nature or social sciences on the other. He found Kelsen की theory क्या कहलाती है? It's very famous. Kelsen gave pure theory of law. Who among the following are or is not political philosopher from the natural school? अब आप ऑस्टिन को पहले ही बाहर कर दो क्योंकि वो नहीं है. ठीक है, Socrates, Aristotle, Locke, they were all natural school के thinkers. तो नॉट में क्या हुआ? ऑस्टिन वैसे भी आ गया. Even if others were given, I think this is a name you should know his theory. Why? Because ज़्यादातर इसके इनके जो jurisprudence questions होते हैं, he is one of the options, and it's very easy to at least be like, हाँ ये तो theory इनकी नहीं है. The law according to Dash is a system of norms which provides some modes of conduct and a specific behavior under the term normative science. अब normative science की बात की थी किसने? Kelsen ने. Okay, so Kelsen was the one who talked about normative science. Now we'll come on to our next passage. Law as an aggregate of legal precepts may be defined with reference to the source of authority or with respect to the form regarded as typical. When thought of in terms of the authority which promulgates it and puts coercion behind it, jurists have spoken of enactment or promulgation by the ruling organ of politically organized writing. Hence, we get definitions of law in terms of the imperative type of legal precepts. But the jurists who looked instead at the form in which the precepts are expressed have thought of traditional and or customary precepts. expressing reason or good morals as the type, and so have defined law as a body of traditional or moral rules of conduct formulated by some authority of politically organized society, but having a deeper foundation in reason. Most significant differences, however, come from the standpoint of purpose from which legal precepts may be regarded. One such standpoint is that the citizen or subject who wishes to know that he should do as an upright and law abiding principle as a person adds the crisis of action. To him, a rule of conduct. On the other hand, Mr. Justice Holmes uh, thought the question as to the nature of a law should not be put from the standpoint of the conscious good man seeking guidance as to what is right, but from the standpoint of unconscious bad man who seeks to know how far he may do what he wishes to do with impunity, or at least a reasonable prospect of impunity. कहाँ तक की सजा नहीं मिलेगी. To such person, law is a body of threats of what the public authorities may do or a person aggrieved may do to him if he does some particular thing he has in mind, or does not do something he wishes to avoid doing. This threat theory of a law has been much urged in the present century. In the same paper, Mr. Justice Holmes speaks of a law from another standpoint, namely the standpoint of a counselor advising clients as to their rights and liabilities. From this standpoint, he says, a law is a prediction of what the courts or administrative agencies will do given a particular state of facts or a particular situation. Now, if you've understood this part, again, we are on jurisprudence. So, who among the following contributed, though differently, in a social contract theory? Now, social contract theory is one of the most famous theories. And ये किसने दी थी? Hobbes, Locke, and Rousseau. These were the three people. अलग-अलग दी थी, एक नहीं दी थी. Everybody has their own theory, but these are called social contract theory. According to Dash, it is a duty of an individual to obey the general will because in that way he is obeying his own will. किसने ये कहा कि general will और personal will एक ही होती है? That was Rousseau. The famous The Republic was written by which of the following who are prominent philosophers of natural school of jurisprudence? Up आता है natural school. We know Holland is not from natural school. The answer is anyhow Aristotle. No, wait. It wasn't written by Aristotle. Okay, sorry, I skipped down to the 54th one. The Republic was written by Plato. ठीक है? Socrates नहीं, Aristotle नहीं, Locke नहीं. Learn the names of their works, all of them, and all the important philosophers. Who among the following are considered to be the founding fathers of natural law school of jurisprudence? तो natural law किससे found किया है? Aristotle ने. It is rightly said by Dash that positive law must conform to natural law. Positive law is valid only to the extent to which it is compatible with natural law. ये बात किसने कही है कि दोनों को एक साथ कंफर्म करना चाहिए? It's Aquinas. Now 56th, who among the following is or are not a part of Renaissance period of natural law school of jurisprudence? So we know that natural law school से काफी दूर थे Austin and Holland, so the answer is D. Now according to Locke, the powers of state are limited and the personal liberty of individuals is significant and therefore should be protected. क्या ये बात सही है? Is it true? Yes, it's true. That is the theory of Locke, where he says कि the powers of state are limited and personal liberty is significant. Who among the following relates state with abstract Leviathan? कौन बात करता है लेवाथियन की? लेवाथियन इज अ वेरी कॉमन वर्ड and it is used by Thomas Hobbes, and you should always be able to match Leviathan with Thomas Hobbes. Who among the following jurists belonging to the National School of Jurisprudence used the phrase "man is born free and he is everywhere in chains" in one of his famous books? ये किसने कहा था कि man is born free but is everywhere in chains? It's Jean-Jacques Rousseau. The Trial and Death of Socrates was written by a very renowned jurist. What's the name of that jurist? It's, I hope you all know that it's Plato. ठीक है, प्लेटो ने ही उनके ऊपर सबसे ज़्यादा वैसे भी काम किया था. So we have done a number of passages. Now we will move on to the next. I think we have done 5, right? Now comes the 6th passage. The law regulates relationship between people. It prescribes patterns of behavior. It reflects the value of society. The role of the court is to understand the purpose of law in society and to help the law achieve its purpose. But the law of a society is a living organism. It is based on a given factual and social reality that is constantly changing. Sometimes the change in law precedes the societal change and is even intended to stimulate it. In most cases, however, a change in law is the result of change in social reality. Indeed, when social reality changes, the law must change too. Just as a change in social reality is a law of life, responsive to change in social reality is the life of law. It can be said that the history of law is the history of adapting law to society's changing need. In both constitutional and statutory interpretation, the court is supposed to exercise discretion in determining the proper relationship between the subjective and objective purpose of law. For the purpose of adopting an approach which furthers legislative policy, it would be appropriate to derive some guidance from the provisions of Maternity Benefit Act 1960. Though it may be stated at the outset of that the Act per se has no application to the PGIMER as an establishment. Not nonetheless, the provisions of the Act of 1961, the Maternity Benefit Act, are indicative of the object and intent of the Parliament in enacting cognate legislation on the subject. Unless a purposive interpretation was to be adopted in the present case, the objective and intent of the grant of maternity leave would simply be defeated. The grant of maternity leave under rules of 1972 is intended to facilitate the continuance of women in the workplace. It is a harsh reality that, but for the such provisions, many women would be compelled by the social circumstances to give up work on birth of a child if they are not granted the leave or other facilitative measures. No employer can perceive childbirth as detracting from the purpose of employment. Childbirth has to be construed in the context of employment as a natural incident of life, and hence the provisions for maternity leave must be construed in that perspective. The predominant understanding of the concept of family, both in law and in society, is that it consists of a single unchanging unit of a mother or father who remains constant over time and their children. This assumption ignores both the many circumstances which may lead to change in one's familial structure and the fact that many families do not conform to this expectation to begin with. Familial relationships, that is, family relationships, may take the form of domestic, unpartnered partnerships, unmarried partnerships, or queer relationships. A household may be a single parent household for a number of reasons, including death of spouse, separation, or divorce. Similarly, the guardians and the caretakers of children may change with remarriage, adoption, or fostering. These manifestations of love and of families may not be typical, but they are as real as their traditional counterparts. Such atypical manifestation of family unit are equally deserving not only of protection under law but also of the benefits available under social welfare legislation. The black letter of the law must not be relied upon to disadvantage families which are different from traditional ones. The same undoubtedly holds true for women who take on the role of motherhood in ways that may not find a place in the popular imagination. किसकी बेंच थी ये? जस्टिस चंद्रचूड़ एंड जस्टिस बोपन्ना. नाउ ऑब्वियसली पहला क्वेश्चन क्या आएगा, क्योंकि आपको नीचे जजमेंट का नाम नहीं दिया है तो यही पूछा जाएगा. एंड द आंसर इज दीपिका सिंह वर्सेस सेंट्रल एडमिनिस्ट्रेटिव ट्राइब्यूनल एंड अदर्स. Now, the Central Services Leave Rules 1972 has been framed under the provisions of which of the following articles of the Indian Constitution? किस आर्टिकल से ये आ रहा है? The answer is 309. Now, in which of the following cases the court emphasized on the duty of court to bridge gap between law and society through the use of purposive interpretation in light of the term social justice? तो social justice की सबसे ज़्यादा बात किस केस में हुई थी is what you need to see. This is Badshah versus Urmila Badshah Godse. Under dash of the constitution, the article basically, the state is empowered to enact beneficial provisions for the interest of women. We know 15 clause 3. The right to reproductive dignity, no, the right to reproduction and child rearing has been recognized as an important facet of a person's right to privacy, dignity, and bodily integrity under Article 21. The similar facet is enshrined under Part 4 of the Constitution. Is it correct with respect to Part 4? क्या ये बात सही है कि ये बात Part 4 में की गई है? For that, obviously, you should be knowing Part 4 क्या है, which I'm supposing you all do. Yes, Article 42. Exactly यही बात करता है वो about fostering and motherhood. 66. What interpretation was provided by Supreme Court in the present case when the appellant was unable to avail the maternity leave due to grant of child care relief for the earlier two children of her husband from the earlier wife? क्या अप्लाई किया था कोर्ट ने? More often than not, it's purposive interpretation. What all was included by the Supreme Court under atypical manifestation of family? So that's a very direct one. We know the answer is D. In which of the following landmark cases the court held that amending power of the parliament under 368 cannot rule over the fundamental rights of Part 3 of the Constitution? अब ये पूरा का पूरा जो आपका list of cases है, it becomes important here. The answer is Golaknath versus State of Punjab. In which of the following cases the court said that preamble is the key to open the mind of the makers? So इसके answer is in re Berubari, although in re Berubari में कहा गया था कि it is not the part, preamble is not the part of the constitution, but that has been overruled. Under which, in Keshavananda Bharati, under which of the constitutional amendments introduced anti-defection laws and inserted an additional schedule in the Indian Constitution? So as I said, सारे के सारे आपको schedules याद होने चाहिए कि कौन किस constitutional amendment से आया है. The answer is 52nd constitutional amendment. Having done with 6 passages, I hope you've understood how you can go about solving the questions. So I'll proceed with the 7th one. And see, इतना time नहीं लगता है. If you have studied well, if you have prepared well, obviously it will take lesser time. So even while I'm explaining in between and I'm stopping in between to explain you people, we are still on the 7th passage. It is evident that on a careful consideration of available pleadings of the defendants, the High Court held that they did not disclose their defense in their written statement, and at the same time did not even contend therein that they are in possession of the sued property. According to us, in such circumstances, when the facts disclose no title in either party at relevant time, prior possession alone decides the right to possession of land. in the assumed character of owner against all the world except against the rightful owner. In that context, it is worthy to refer the maxim possessio contra omnis valet praeter your cui issue sit possessionus. We are of the considerate view that the same analogy is applicable in a case where even in the event of death of one of the defendants, when the estate or interest was being fully and substantially represented in the suit jointly by other defendants along with deceased defendant, and when they are also his legal representatives. In such cases, by reason of non-impleadment of all other legal heirs consequential to the death of the said defendants, the defendants could not be heard to contend that the suit should stand abated on account of non-substitution of all other legal representatives of the deceased defendants. In this case, it is to be noted that along with the deceased third defendant, the original defendant number 1 and 2 were jointly defending their joint interest. Hence, applying the ratio of the aforesaid decision and taking into account the fact that the appellants, the original defendants number 1 and 2, despite the death of original defendant number 3, defended the suit and preferred and prosecuted the first appeal. Upon the death of the second appellant, the joint interest is being fully and substantially taken forward in the proceeding as well as by the first appellant along with the substituted legal representatives of the deceased second appellant. We do not find any reason to disagree with the conclusions and findings of the court below for rejecting the contention that the suit ought to have held abated owing to the non-substitution of all legal heirs of deceased third defendant against all defendants. For the same reason, the contention that the suit was bad for non-joinder of necessary parties of all his legal representatives also has to fail. Now, this is an excerpt from a case which I am sure you would have understood while I was reading. सबसे पहला क्वेश्चन विच आई थिंक वी ऑल न्यू वाज कमिंग कि ये जो मैक्सिम हमने पढ़ा है उसका मतलब क्या है. द आंसर इज ए. He who has possession has right against everyone save him from who has the exact right. Now possession पे जो आपके ये होते हैं maxims, they come more than any other. So yeah, try to learn them. And international law, यहाँ पे इन दो जगहों पे a lot of Latin maxims are asked. Now 72nd, which of the following is the correct maxim for the third party? थर्ड पार्टी के लिए आप क्या सही मैक्सिम डालोगे? इट्स जस्ट डर्टी. नाउ जस्ट डर्टी का मतलब क्या है? इज अ राइट ऑफ थर्ड पार्टी एज टू द प्रॉपर्टी इन अनदर्स पोजेशन. व्हाट वाज हेल्ड बाय द कोर्ट इन दिस केस? ये जो केस ऊपर पूरा हम लोग ने पढ़ा है इसमें कोर्ट ने क्या बोला था? The person in possession of the property has to establish better title against the owner. In a suit for possession, if both parties have not established title, then the party who proved prior possession will succeed. This is the answer B. 74. Statement 1. Civil appellate jurisdiction can be exercised by Supreme Court only when their High Court provides certificate of appeal under 134A. Statement 2. The High Court will certify for appeal when it is of the opinion that there exists a substantial question of law or fact which should be decided by the Supreme Court. So, the answer is, we all know that the first statement is correct, but the statement 2 is false. Okay? This is not of fact. It has to be just the law. What is the effect of misjoinder of plaintiffs? Now, misjoinder, non-joinder, plaintiffs ka, defendants ka is important, and you have to be clear with the concepts of this. The answer to this is C. Dismissal हो जाता है, depends whether misjoinder affects the merits of the suit or not. Which of the following is incorrect regarding section 52 of the Transfer of Property Act? Now section 52 कुछ sections हैं ट्रांसफर ऑफ प्रॉपर्टी के which you need to study. जैसे 70 ये आपका 52nd सॉरी जो हम लोग क्वेश्चन 76 section 52 is a very important section. It talks about lis pendus. The answer is B. It applies over all movable and immovable property which is subject of the suit. TPA पूरा पढ़ने में many students ask कि मैम TPA कैसे prepare करना है. Don't give too much time, but अगर TPA has been your good subject, then give a reading to the Bare Act. If not, at least I'm not suggesting those books in general, but what is known as Dukki might help क्योंकि वो जल्दी कवर हो जाएगी and probably you'll just be refreshing your principles. कुछ questions आते हैं but बहुत ही pet sections हैं from which questions can be asked. Now 77. Choose the correct statement. 52. Section 52 of TPA comes in force even after injunction has been passed by the court. No. Section 52 bars the court from granting relief of injunction in a particular matter. No. An order of temporary injunction is preemptive in nature, restraining the act of alienation by a party, whereas Section 52 comes into play after alienation takes place during the pendency of the suit. C is the correct answer. 78th. In which case, court observed that provision of Section 52 of Transfer of Property Act did not indeed annul the conveyance or the transfer otherwise, but to render it subservient to the rights of the parties to the litigation. Now, this is again one of those questions. If you know, you do. If you don't, don't take a guess. The answer is Thomas Press India Limited versus Nanak Builders and Investors Private Limited. 79th. Which of the following is correct regarding Nair Service Society Limited versus Rev. Father K.C. Alexander, 1968? So again, आप पढ़ के पूरा देख लें. Of course, there might be options which are not correct in law. अगर ऐसा नहीं है, then don't take a guess. Here the answer is A. A party ousted by the person who has no better right is, with reference to the party so ousting, entitled to recover by virtue of possession he had held prior to the ouster, even though possession was without any title. 80th is, in which case it was held that injunction is a possessory remedy. A very straightforward question. Elimination rule के अलावा you can't take it out. The answer is Punaram versus Motiram. Now coming to our 8th passage. The intent of our order today is to activate a dormant provision of the Constitution of India, Article 224A, for the appointment of ad hoc judges to deal with the unprecedented situation arising from the backlog of cases pending in the High Courts, which has now crossed the figure of 57 lakhs, coupled with the consistent ratio of vacancies of almost 40%. Any constitution has to be dynamic, and thus, even if the intent behind including the provision as it appears in the Constitution Assembly debate was slightly different, nothing prevents it from the signature not verified being utilized to, obviously it has to be not signature, not verified, being utilized to subserve an endeavor to solve an existing problem. For as it is always said, change is the only constant. India was fortunate to have some of the best minds working in the framing of our constitution as members of a constituent assembly. The Indian constitution is an elaborate one, taking cues from experience of various democracies. One of the essential aspects of our constitution has been separation of power between judiciary, executive and legislature. Chapter 5 of Part 4 of the Constitution of India, commencing from Article 214 up to 231, relates to the High Courts in the states. Article 217 provides for the appointment and conditions of the office of a judge of the High Court, wherein the current age of retirement is 62. We may say that broadly it is amongst the youngest ages of retirement of judges of the apex court of a state in comparison with other democracies in the world. The aforesaid article begins with a non-obstinate clause and was placed so that a request can be made to any person who has held the office of a judge of that court or any other high court to sit and act as a judge of the high court for the state. The second aspect is that while sitting and acting such a judge would be entitled to allowances as the president may by order determine and have all the jurisdiction, power and privileges of high court judge. But for all other purposes shall not be deemed to be a high court judge. I'm sorry for the breaking voice again and again. I am in Delhi, so of course we have unlimited pollution which is causing the crackness. So sorry for the disturbance. The above excerpt has been taken from which of the following judgments? Where the Supreme Court of India actively sought to activate a dormant provision of the Constitution for appointment of ad hoc judges to deal with the unprecedented backlog of cases. The answer is C. Lok Prahari versus Union of India. इसमें कोर्ट ने कहा था कि इतने ज़्यादा पेंडिंग केसेस हैं, जजेस अपॉइंट हो नहीं रहे हैं, तो माइट एज वेल एड हॉक जजेस को लेके आइए. In this case, the court emphasized on a huge pendency of high courts of different states on the basis of the data drawn from which of the following bodies. So, इसमें जो डेटा दिया गया था वो नेशनल जुडिशियल डेटा ग्रिड से दिया गया था. The Supreme Court advocate on record versus Union of India. The Supreme Court of India, by a dash majority, restored the collegium system of appointment of judges by holding that the National Judicial Appointment Commission is ultra virus the Constitution. Now this is a very very important case. अगर आप obviously आप लोग कर ही रहे होंगे अपने judgments, so do not miss the judgments in the the line of cases for the collegium system. The answer is B, 4:1. The concept of independence of judiciary is taken from which of the following constitutions as shown from the provisions and features of the Indian Constitution? We all know it's the US Constitution. The consent of who amongst the following is required for appointment of retired judges as a high court judge at a high court level? Retired judges को हम लोग दोबारा अपॉइंट कर सकते हैं, लेकिन इसके लिए किसकी परमिशन चाहिए is your question. Just a second. Yeah, so for requirement for appointment we know कि अगर कोई भी appointment हो रहा है आपका as for the retired judge, तो consent भी हमें retired judge की ही लेनी होगी, right? So the question has to be read carefully. Consent of who has to be taken, right? It's not the permission that has to be taken या who appoints the judge. Consent कौन करेगा? जिसको appoint किया जा रहा है, he has to consent. He cannot appoint himself, but he has to consent for that appointment. So read the questions carefully. The Article 224A, which was deleted by the 7th Amendment of the Constitution, was reintroduced by which of the constitutional amendments? Now there are rarely reintroductions, so you have to know that this is the 15th Constitutional Amendment. By which of the following cases the court reintroduced collegium system in the Indian Constitution for the appointment of judges of the higher judiciary? जो पूरे सारे cases हैं, please do cover them. Again, I'm saying it is the Supreme Court advocates on record. Judges transfer case 1 and 2 is not the answer to it. This Scora versus Union of India is one of the major cases on this topic. Who among the following was appointed as ad hoc judge under 224A for Ayodhya case? Now, Ayodhya case में आप ruling और judgment पूरी ना पढ़ें, लेकिन ये सब जो चीज़ें हैं इसको ध्यान रखें. All these peculiar things that have happened in that case. The answer is Justice O.P. Srivastava. The executive, legislature and judiciary have assigned with different powers and functions according to the doctrine of separation of powers. बात यह है कि separation of powers की theory दी किसने थी? This was by Montesquieu. In which of the following reports the Law Commission of India advocated for the appointment of retired judges as ad hoc judges in the interest of clearing backlog of cases in the High Court? तो Law Commission अभी भी एक ongoing था So please read about the law commissions. Do read about the law commission that was just formed. Here the answer is 188th report for proposals of constitution of high-tech fast-track commercial divisions in High Court, 2003 में. Now we come to our last passage. The area declared by the state comprising of a total area of 9,07,070 hectares and an area of 23,29,659 hectares of area as a forest area or deemed forest is already existing as co-sensitive, co-fragile buffer safety zone in that state within which no non-forest activities is allowed without proper permission under the Forest Conservation Act of 1980. The state of Rajasthan has opposed the proposal for declaring 10 kilometers beyond the boundary of sanctuaries and national parks being declared as ESZ. The roles of the state cannot be confined to that of the facilitator or generator of economic activities for immediate upliftment of the fortunes of the state. The state also has to act as a trustee for the benefit of the general public in relation to natural resources, so that sustainable development can be achieved in the long term. Such role of the state is more relevant today than possibly at any point of time in the history, with the threat of climate catastrophe resulting from global warming looming large. This court has highlighted the public trust doctrine in the case of dash. Here comes your question. An opinion by the public trust doctrine is a part of the land of law, law of land. In paragraph 25 of the said judgment, as reported, this doctrine has been explained with reference to writings of Joseph L. Sachs, professor of law, University Michigan, the proponent of modern public trust doctrine. Public trust doctrine क्या कहती है? Primarily rests on the principle that the certain resources like air, sea, water, and forest have such great importance to people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources being a gift of nature, they should be made freely available to everyone, irrespective of status and life. The doctrine enjoins upon the government to protect the resources for enjoyment of the general public rather than to permit the use for private ownership or commercial purpose. So, had it not been for this, for Joseph L. Sachs, who was a professor of law, as we read, actually में ये होता कि सांस लेने के हम लोग पैसे दे रहे होते, because by now somebody would have said that I buy the whole oxygen. हम सारी oxygen खरीद रहे हैं, so we were saved by this person. Now, this extract is from which of the cases pertaining to Jamua Ramagarh Wildlife Sanctuary of CEC? The answer is TV Godavarman versus Union of India. It's a very famous line of cases है Godavarman के नाम से. So while we have a lot of concentration of MC Mehta, we also have a few of Godavarmans. Which of the following can replace one in which the public trust doctrine was laid down? Now, as we talked about MC Mehta, here comes the answer. MC Mehta versus Kamal Nath. पर MC Mehta में ज़्यादातर Union of India होता है. Don't get confused and always mark Union of India. ज़्यादातर है, that's true, but other things are also there. Here, for example, it's Kamal Nath. CEC is referred by the court in the instant matter stands for. So, CEC is a very, very common committee जो काफ़ी बात होती है environment cases में. The answer is Central Empowered Committee. Now, eco-sensitive zone means what? जो हमने ESZ पढ़ा था, तो वो ESZ होते क्या है? तो ESZs होते हैं जो कि define किए जाते हैं. These are sensitive zones जिनके आसपास एरिया सराउंडिंग प्रोटेक्टेड एरिया नेशनल पार्क या वाइल्ड लाइफ सैंक्चुरी. अगर कहीं वाइल्ड लाइफ सैंक्चुरी है तो अगर हम लोग एकदम पास तक की उसके व्हीकल्स और ये सब आने देंगे तो उसके अंदर जो वाइल्ड लाइफ है, द एनिमल्स, द फॉरेस्ट, एवरीथिंग विल ऑल्सो गेट अफेक्टेड. तो जो हम लोग के ये सेंचुरीज और पार्क्स होते हैं, इनको भी कवर किया जाता है और ये इको सेंसिटिव जोन्स में आते हैं. एरिया डिक्लेयर्ड ESZ बाय मिनिस्ट्री ऑफ एनवायरनमेंट एंड फॉरेस्ट एंड क्लाइमेट चेंज. ये कौन डिक्लेयर करता है? ऑब्वियसली द मिनिस्ट्री डिक्लेयर्स इट. दे आर द शॉक ऑब्जर्वर फॉर प्रोटेक्टेड एरिया. पर्पस क्या होता है कि अगर फॉर एग्जाम्पल दिस इज द प्रोटेक्टेड एरिया, यहाँ तक कि वी विल मेक द ESZ, जिससे कि जो भी पोल्यूशन आए वो इतने में ही अब्जॉर्ब हो जाए एंड वाइल्ड लाइफ तक वो ना पहुंचे. So the answer is D, all of the above. Now, statement 1. Eco-sensitive zones are the areas that are declared under Wildlife Protection Act 1972. Statement 2. The purpose of the declaration is to prohibit all kind of human activities in that zone except agriculture. Now, do you think that agriculture is something that can be allowed? The answer is no. वहाँ पे agriculture of all the things क्यों allow कर देंगे? They are areas declared under Wildlife Protection Act. So while it's a huge chance to say yes, the answer is no, and it's actually the Environment Conservation Strategy Act. It's of 2002. उसके अंदर डिक्लेयर किया जाता है. So not Wildlife Protection Act. So the answer is D, both are false. तो 1 तो आपको मतलब 2 तो आपको पक्का हो ही जाएगा, क्योंकि एक्सेप्ट एग्रीकल्चर कोई मतलब नहीं. एग्रीकल्चर में पेस्टिसाइड्स डालते हैं, इतने ज़्यादा वाटर एंड एवरीथिंग इज कंज्यूम्ड इन अ पर्टिकुलर मैनर, प्लस इट मेक्स नो सेंस. You might think कि because agriculture is also something wherein we are growing trees, that's for a very very different purpose. There are crops meant to be consumed, so it's not that. तो जैसे ही आपको 2 समझ में आ जाता है, you know that the answer is either B or D. But yes, this is an information you have to particularly know. In which of the following case question of having ESZ around protected forest was examined by Supreme Court. तो ये भी चैलेंज हुआ था कि इसके आसपास क्यों you have to make the ESZ zones. ये चैलेंज किया गया था गोवा फाउंडेशन वर्सेस यूनियन ऑफ इंडिया में, एंड ऑब्वियसली द कोर्ट upheld it. That is why we still have them. In which case, court held the precautionary principle is an essential feature of the principle of sustainable development. Indian courts ने precautionary principle, sustainable development का principle, polluter pays, even this public trust doctrine, ये सब absorb कर लिए हैं by the judiciary. Judiciary ने अलग अलग केसेस से सब रिकॉग्नाइज किए हैं, एंड इट इज़ इम्पॉर्टेंट फॉर यू टू एक्चुअली सी कि किस प्रिंसिपल को कहाँ पे अडॉप्ट किया गया है. इसको प्रिकॉशनरी प्रिंसिपल को वेलोर सिटीजन्स वेलफेयर फोरम वर्सेस यूनियन ऑफ इंडिया से वी हैव रिकॉग्नाइज्ड इट एज अ पार्ट ऑफ आवर लॉ. द ओनर्स ऑफ प्रूफ इन केस ऑफ प्रिकॉशनरी प्रिंसिपल लाइज ऑन होम. अब हमने प्रिकॉशन लिया, ये कौन बताएगा? It has to be the developer or the industrial in the industry. जितने भी ये principles हैं, they mostly end up acting against the industries, because we know कि industries are very important, but we also know that industries do cause a main threat and problem to our environment. इसलिए इस तरह के जितने भी सवाल होंगे, the answer will mostly be the developer. The developer has to prove कि हाँ उन्होंने precautionary principle लिया था. They did everything to save the environment. They did everything to lessen or minimize the harm to the environment, the air, the water, the soil, everything. Under which section of Wildlife Protection Act an area can be declared a sanctuary? Now again, this is something wild guesswork करना हो तो कर लें, otherwise leave it. The answer is section 26A. Which of the following was not a recommendation under report entitled Note regarding safety zones, ecosystem zones around national parks and wildlife sanctuaries? Now this is a report which is obviously quite an important one. Let's read, but yes, it is again one of those where you know the answer only then you know it. For the purpose of identification and declaration of safety zones around national park, wildlife sanctuaries, hereinafter as protected areas, the protected areas based on their areas are classified into four categories A, B, C, D. This is not the correct answer. Wherever two or more protected areas are contiguous to each other, such protected areas will be placed in appropriate category based on the sum of their total areas. Sorry, this was a recommendation and even this was a recommendation, both of them. The activities such as setting up of industries other than including the list of prohibited activities, hotels, restaurants including resorts, commercial helicopter service, hydel projects, irrigation projects, canals, laying of transmission lines and distribution lines above 33 kV, roads of more than 5-meter width, and collection of boulders, gravel, and sand from the riverbed will be treated as prohibited activities. Now, this is the actual answer. C. This was not uh, stated in the recommendations. As I said, if you know it, only then you know it. I'll read D. The safety zone in respect of protected areas falling in category A and category B may compromise of all the areas, including non-forest areas, falling within the distance of 2 kilometers and 1 kilometer respectively from the boundaries of protected area. Such distance in respect of protected areas falling within the category C and category D may be kept at 500-meter and 100-meter respectively. So now, as you can see that we are almost nearing the end. You know, uh, two more questions are left. Let's take up another while we still have time for less time, but still we have it. So let's try to complete it. I hope you're solving it with me. If you've already attempted it and just want to know the answers, then I have no issues. But yes, try to solve it along. This is an indication that some of the rights conferred by Part 3 are to be honored by and also enforceable against non-state actors. For instance, the right conferred under Article 15, Clause 2A and B, 17, 20, Clause 2, 21, 23, 24, 29, Clause 2, etc. are obviously enforceable against non-state actors also. The owner of a shop, public restaurant, hotel, or place of entertainment, though non-actor, cannot deny access to citizens of India on grounds of religion, race, caste, etc. In view of Article 15(2)(a), so is the case with wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partially out of state funds or dedicated to the use of general public in view of 15(2)(b). The right not to be enforced within and disability arising out of untouchability is available against the non-state actors under Article 17. The right against double jeopardy and the right against self-incrimination available under 20 clause 2 and 3 may also be available even against non-state actors in the case of prosecution on private complaints. We need not elaborate more as the table given above places all rights and perspectives. This Article 21 guarantees every person that he shall not be deprived of his life and liberty except according to the procedure established by law. Going by the scheme of Part 3, it is clear that the state has two obligations: not to deprive a person of his life and liberty except in accordance to the procedure established by law, and to ensure that the life and liberty of the person is not deprived even otherwise. Article 21 does not say that the state shall not deprive a person of his life and liberty, but it says that no person shall be deprived of his life or liberty. When the Constitution was adopted, our understanding of the word life and personal liberty was not as it has evolved over the past 7 decades. Similarly, it was not imagined or conceived at that time that anyone other than the state is capable of depriving the life and personal liberty of a person except by committing a punishable offense. But with expanding horizons of a philosophical understanding of life, law, and liberty, the advancement of science and technology, we have come to realize that life is not an empty dream, and our hearts are not muffled drums beating funeral marches to the grave, nor is life a tale told by an idiot full of sound and fury, signifying nothing. So this is an extract from Kaushal Kishore versus State of UP. Now the thing is that which of the following judges wrote the majority opinion? The answer is D. Justice V. Ramasubramaniam. The restrictions imposed by 19 clause 1 of the constitution have been borrowed from where? Now they have been borrowed from Ireland, जितने भी 19 में हैं हम लोग के restrictions 19 clause 2 में. In which of the following cases does the court held that the imposition of pre-censorship on a journal is restriction on the liberty of press, which is essential part of the right of freedom of expression? So, answer is Brijbhushan versus State of Delhi, 1950. Assertion क्या है? Under the guise of invoking other fundamental rights or under the guise of two fundamental rights talking a competing claim against each other, additional restrictions not found in 19 clause 2 cannot be imposed. A ground lined in article 19 clause 2 for restricting the right to speech are exhaustive. इसमें से the answer is that they both are correct, but ये इसका explanation नहीं है. They both are individually correct, but this is not the reason. Which of the following constitutional provisions give immunity to a member of parliament from the application of 19 clause 2? Now this is very important, especially in light of what's going on with Mahua Moitra. So to read them, the answer is article 105. Most of the members of parliament received bribes to vote against the no confidence motion issued in parliament against the prime minister. Are the MPs liable to punishment? Agar the answer is yes, then obviously the question is under which law? Then the answer is no. They are not. So they are actually not liable to be punished, as strange as it may sound. And this comes from a judgment named P.V. Narasimha Rao versus State. उसमें ये कहा गया था. Now, which of the following statement is not true regarding the aforesaid judgment? जिसकी बात हुई है उसमें से what is not correct? In the guise of two competing claims, additional restriction can be imposed under 19 clause 2. That's not true. Assertion: the fundamental right under Article 19 has vertical effect in its operation. Whether constitutional rights regulate and impact only the conduct of a government and governmental actors in their dealings with private individuals, they are said to have a vertical effect. Now, if you're talking about the vertical effect, the answer is that both are true, but R is not the correct explanation of A. So the fundamental rights do have a vertical effect in operation. It is also true that where constitutional rights regulate and impact only the conduct of the government and government actors in their dealings, the private individuals, they are said to have a vertical effect. But this is not the reason of your statement given above. In the light of aforesaid judgment, can a minister's statement be vicariously attributed to government through the notion of collective responsibility if it is inconsistent with fundamental rights? The answer is no. The government will not be vicariously liable. अगर हम लोग government को vicariously liable करने लगेंगे तो the government will be answerable to every MP's fault, which obviously will hamper the functioning of the government a lot. Now, the last question for this session: which of the following maxims relate to the concept of sovereign immunity? तो जहाँ तक हम इतने की बात कर रहे हैं, this is what this is all sovereign immunity जिसकी हम लोगों ने बात की जो MPs को मिलती है. A, res non praetes pecre. So जो immunity है state देती है MPs को, MLAs को, so that their work can go on seamlessly and they are not charged for everything they say and do in the parliament. So that brings us to the end of our session. I hope it has been helpful. I hope you were able to solve along with me. Now there is one question left, but I would like you to go and see the PDF. Attempt this one question. Why should you attempt it? भाई ये तो क्वेश्चन आना नहीं है, मॉक क्यों दे जब ये क्वेश्चन ही आना है? तो फर्स्टली देयर माइट बी अ चांस कि आप इतने मॉक्स देंगे तो उस प्रिंसिपल पे क्वेश्चन आ जाएगा, ठीक है। नाउ यू मस्ट हैव लर्न सो मेनी थिंग्स अबाउट सो मेनी टॉपिक्स इन दिस वन मॉक। जब आप बहुत सारे मॉक्स करेंगे तो आपको उनके टॉपिक्स, उनके प्रिंसिपल्स के बारे में पता चलेगा। अगर आपके एग्जाम में उन प्रिंसिपल से रिलेटेड कुछ भी आता है, यू विल बी एबल टू आंसर इट, राइट। सेकेंडली, आपको टाइम करना आएगा। आपको ये भी समझ में आएगा कि हाउ मच ऑफ योर गेस वर्क इज एक्चुअली करेक्ट। कुछ लोग के गेस वर्क कभी काम नहीं करते, कुछ लोग के गेस वर्क आर ग्रेट, दे वेरी इंस्टिंक्टिव, नो वेयर यू स्टैंड, यू नो। जितना ज़्यादा आप मॉक्स देंगे, आपके इंस्टिंक्ट्स भी उतने बेटर होते जाते हैं। ऑल्सो द क्लैट PG for 2025, our champion batch, is open. So whoever wants to attempt the December 2024 paper, उसके लिए you can enroll. You will get all the facilities, you will get all the preparation material that you require, and yeah, so all the best for this exam. I hope that you all do wonders, and the learning in the process is the main thing, so don't forget that. Good night, everybody. Take care, and see you in the next session. Bye bye.